What if I told you the most powerful force slowing down this presidency isn't elections, isn't protests, and isn't Congress, but a group of judges with no armies, no budgets, and no applause? And what if I told you they're actually winning? Stay with me, because the story you've been told about the courts folding under pressure doesn't survive contact with the facts. For more than a year now, we've been living through what can only be described as a stress test of the American constitutional system, not a hypothetical one. Not a classroom example, a real-world collision between presidential power and the rule of law. And early on, it looked ugly. Executive orders flying out at breakneck speed, policies rolled out with little regard for legality, people harmed first, explanations promised later, if at all. Congress, meanwhile, didn't just fail to check the president. In many cases, it vanished entirely. When its own powers were trampled, appropriations ignored, statutes selectively unenforced, Congress responded not with resistance, but with loyalty or silence. So the question became unavoidable. If Congress won't act, who will? That question is where the federal courts enter the story. Former FBI Director James Comey recently described what happened next, using a metaphor that sticks, a bungee jump. The administration jumped hard. For a while, it felt like the cord kept stretching. Illegal orders, open defiance, rhetoric aimed directly at judges, threats of impeachment, talk of dismantling courts altogether, and many people watching thought the same thing. This time, the cord might snap. But here's the part that doesn't get enough attention. It didn't. Instead, the cord snapped back, slowly at first, unevenly, case by case, judge by judge, but unmistakably. And the main force behind that snapback wasn't political courage. It wasn't public opinion. It was something more boring and more durable. The institutional culture of the federal judiciary. Here's what that means. Federal judges, no matter who appointed them, tend to care obsessively about legitimacy, about reputation, about the idea that when history looks back, their names won't be attached to cowardice. They don't move fast. They don't speak loudly. But when they move, they tend to move together, not in conspiracy, but in shared professional norms. So ask yourself this: if the courts were really captured, really intimidated, really broken, why is the administration losing so often and losing in so many different ways? Look at the numbers. As of early February 2026, there have been over 600 civil lawsuits challenging Trump administration actions. In more than 150 of those, courts have at least partially halted policies through injunctions or restraining orders. In cases that have actually reached final judgment, plaintiffs have beaten the administration nearly 10 times more often than the administration has beaten them. That is not normal. That is not what a judiciary in submission looks like. And it's not just civil cases. The Justice Department's attempt to weaponize prosecutions has gone badly, sometimes spectacularly so. High-profile indictments dismissed, attempts to install loyalist U.S. attorneys blocked, grand juries refusing to indict, trial juries refusing to convict. Ask yourself, when was the last time you saw this many prosecutorial failures across so many jurisdictions? Now, critics will say, sure, but those are just lower courts. The Supreme Court is where it really matters. Fine, let's talk about the Supreme Court, because here's where the narrative really breaks down. You've probably heard this claim that the Supreme Court has quietly sided with the administration through emergency orders and procedural decisions. And on the surface, the numbers look troubling. The government wins a high percentage of the emergency applications it actually brings. But here's the question almost no one asks. Which cases does the administration not bring to the Supreme Court, and why the Solicitor General doesn't appeal everything? Far from it. Out of hundreds of losses, only a small fraction ever make it to the court, and an even smaller fraction involve requests for emergency relief. Why? Because the administration knows where the lines are. This is the court's invisible power, the influence it exerts without ever issuing an opinion. Lower court injunctions stay in place not because the Supreme Court intervenes, but because the government predicts it won't win if it tries. That predictive restraint matters a lot. Take immigration. The administration attempted to revive deportations without process under the Alien Enemies Act, a move so aggressive it startled even seasoned observers. The Supreme Court issued an interim order last spring, and just like that, the effort stalled, not temporarily, effectively, indefinitely. Ask yourself, if the court were truly aligned with the president's most aggressive claims of executive power, would that order exist at all? Then there's domestic deployment. When a lower court blocked the deployment of the National Guard in Chicago, the administration asked the Supreme Court to step in. The court declined, and the reasoning, quiet, restrained, but unmistakable, prompted the administration to pull back similar deployments in other states. No speech, no press release, just a signal. And perhaps most striking of all, the Federal Reserve. In a single paragraph of dicta, the court cast serious doubt on the president's ability to fire the Fed chair. Just one paragraph. No sweeping ruling, and yet the administration immediately backed off its most aggressive Article 2 claims. Why? Because even this Supreme Court, often described as sympathetic to the unitary executive, appears unwilling to cross certain institutional red lines. So here's the uncomfortable truth for both sides of the debate. If you think the courts are weak, the data doesn't support you. If you think the courts are perfect, reality doesn't either. This system is reactive, it's slow, it's messy. There are moments, like the current chaos in Minnesota, where it looks fragile, even dysfunctional. And yes, some lower court decisions are overwrought or performative, but zoom out. What do you see? You see a judiciary absorbing unprecedented pressure and still functioning, still enforcing compliance, still saying no when it matters most. James Comey put it bluntly: the test of the rule of law isn't whether you like every decision. It's whether the system holds even when you don't. And so far, despite threats, defiance, and open hostility, it has. The bungee cord has snapped back. The real question now is this: does it keep holding, or does it finally break? So where does that leave us now? If segment one was about the snapback, the moment the judiciary stopped bending, then this part is about something harder to measure, but far more important: what happens next, and whether this resistance is durable. Because history doesn't just care that institutions stand up once, it cares whether they keep standing. And that's where the debate around the Supreme Court becomes unavoidable. Critics argue that the court's emergency docket, its interim orders, has leaned too heavily toward executive power. They point to stays granted, injunctions narrowed, explanations kept short or non-existent. They ask, why so little transparency? Why so much deference? Those are fair questions, but here's the deeper one most people don't ask. What exactly is the Supreme Court trying to manage right now? The court isn't just deciding cases, it's managing a system under strain. Horizontally, it has to check a president who has shown open hostility toward judicial authority, who has tested compliance, mocked rulings, and flirted with defiance. The court has no enforcement arm, no marshals it can deploy at will. Its power is ultimately persuasive and institutional. Vertically, it has to rein in a decentralized network of lower courts, hundreds of judges responding to dozens of novel legal theories, often under emergency conditions. Some of those rulings are careful, some are rushed, a few are clearly excessive. And every time the Supreme Court intervenes, it sends a signal, not just to the parties in the case, but to the entire system. So ask yourself, is restraint always weakness, or can restraint sometimes be strategy? Consider what the court has not done. It has not greenlit mass deportations without due process. It has not endorsed domestic military deployment against civilians. It has not given the president a free hand over independent financial institutions. It has not broken with a century of birthright citizenship doctrine. Those are not small things. At the same time, the court has avoided maximalist rhetoric. It hasn't declared constitutional emergencies. It hasn't framed the presidency as an existential threat. Instead, it has issued narrow orders, temporary stays, procedural rulings, often frustrating, often opaque. Why? Because the court may be trying to do something subtle, lower the temperature while holding the line. That doesn't satisfy people who want clarity now. It doesn't comfort those who fear democratic backsliding. And it certainly doesn't make for viral headlines, but effectiveness and visibility are not the same thing. One of the most overlooked aspects of this moment is compliance. Not perfection, not justice, in every case, compliance. Despite all the talk of defiance, the administration has, again and again, ultimately complied with court orders. Sometimes late, sometimes begrudgingly, sometimes only after clarification, but it has complied. That matters more than rhetoric. Because once open defiance becomes normalized, the system changes permanently, and we are not there yet. This is why focusing only on the Supreme Court's win-loss ratio on emergency applications misses the point. The real metric is how many unlawful policies never fully take effect because courts intervene early, or because the government decides not to push its luck. That's the quiet success story. Lower courts issue injunctions. The government assesses its odds. The Solicitor General declines to appeal. The policy stalls. Life goes on. No drama, no decision day, no constitutional showdown, just law working. And yet, this is the part we can't ignore. Nothing about this equilibrium is guaranteed. Judges are human. Courts rely on legitimacy. That legitimacy depends on public acceptance and political restraint. Threats against judges are rising. Calls to dismantle courts are no longer fringe. Congressional leaders have openly flirted with retaliation against unfavorable rulings. So ask yourself, how long can any institution hold if one branch refuses to respect boundaries and another refuses to defend them? The judiciary is doing its job, but it was never meant to do it alone. This is why the phrase "the system as a whole" matters so much, because when people say the courts have stood tall, what they really mean is that the last functioning check is still functioning. That's not a victory lap, that's a warning light. James Comey's framing is useful here. He reminds us that the rule of law isn't about outcomes you like, it's about process holding even when the pressure is intense, even when the person in power is popular with half the country and hostile to constraints. And by that test, so far, the judiciary has passed, but so far is doing a lot of work. The bungee cord analogy cuts both ways. A cord can snap back again and again, but every jump puts stress on the fibers. Every stretch weakens something. So the real question isn't whether the courts have stopped Trump. They haven't, and they were never supposed to. The real question is this: have they preserved the space for accountability to exist at all? Right now, the answer appears to be yes. Lawsuits are still filed, injunctions are still issued, appeals are still heard, orders are still followed, the language of law still matters. That's not everything, but it's not nothing. And it's why sweeping claims of judicial collapse are premature. It's also why complacency is dangerous, because systems don't usually fail all at once. They erode slowly, quietly, case by case, norm by norm. The federal judiciary has, up to now, resisted that erosion. Not heroically, not dramatically, but persistently. And that persistence may be the most important thing it has going for it. So when you hear someone say, the courts are useless, ask them, then why is the administration losing so often? When you hear someone say, the Supreme Court is captured, ask them, then why does the government keep backing down? And when you hear someone say, the rule of law is dead, ask them, dead compared to what and by whose standard? The story of this moment isn't about collapse. It's about strain. It's about resistance. It's about a system bending without breaking, for now, because history is still being written, and the next jump hasn't happened yet. The court is holding. The only question left is whether we notice before it's tested again.